the Supreme Court that borders on this law, I'll be bold to tell you that this is the position of the law. Not only as laid down by the Supreme Court itself, but as laid down by the law. So when you ask me what is my opinion, I have an opinion. I have always stated it. Number one, nobody in Nigeria, no party can win an election petition. Because the electoral law has made it so much that Inec has a presumption given to it by the law that whatever it does is presumed to be correct. Therefore, in any election petition, Inec only comes and says, yes, I have conducted the election according to the law, and tenders all the documents he used. At the stage he tenders those documents, the law says, yes, the law presumes that what you have tendered is correct. Therefore, the respondents, which is the defendants now, will now have to come to challenge. Number one, that law has to change. We have to change it in a way that we will say, Inec, the law says do this, come and show us that you did what the law says you should do. Rather, for the law to back you behind and say, yeah, what you did was correct. So that is the first. If that one is not removed, you will never win an election against Inec. Secondly, the two political parties that are challenging the election, I'm forgetting the facts. Some people were killed here, some people, no, that is not my concern. My concern is what are the legal basis upon which they are challenging it. 3 areas. Tinubu is a crook, he was jailed. The vice president and Tinubu was nominated for 2 positions. Section something of the constitution says if you don't get 25% in 2 states, in Abuja and the other state, you cannot be president. So these are legal points. So you and I can discuss that. Now the Supreme Court says, fortunately, they have given a judgment, which I said on television 3 weeks ago, that there's no merit. And to be honest, I cannot see why a lawyer should have brought. The Supreme Court has already said, look, a man cannot try to contest for 2 posts, senator or governorship, in any election. There was a case in which they said, if you do so, we will nullify it. The opposition today are using the other case where the Supreme Court said, if you do so, we will nullify it, without looking at the facts. In the case where the Supreme Court said, if a man is nominated for 2 positions, that case presupposes that a man should not be nominated. But in that case where the Supreme Court says, you are a fool, you should not have done it, it was a case where 2 parties, 2 political parties, nominated 1 man for 2 posts. But in this case now, where a party nominates him, the Supreme Court has already said, look, if you are not a member of my party, what is your business bringing me? You are a busybody. So there are cases there for any lawyer to see. Now for the opposition now to be rushing to court, to be relying on the Supreme Court judgment that says 2 political parties cannot sponsor 1 person. But if 1 political party sponsors 1 person, then if you are not within that party, you cannot challenge it.
The issue of disqualification of candidates, we understand that the Electoral Act has been amended to make it an issue for before the elections and even after the elections, such that the tribunals can entertain it.
Well, I am not saying. What you are telling me now is whether it's a pre-election or whether it's a post-election or whether it can be taken by the tribunal. Oh, no. My problem is that whichever time it's being taken, that issue can be taken by the tribunal. But on this particular occasion, the circumstances that are being used at the tribunal, to my understanding, is wrong. Shettima is only from APC, and it is PDP that is challenging him. Therefore, they are meddlesome, they are whatever the Supreme Court named them. So there is no merit in that argument at all. So in the 4 things that they are presenting, 1, that Tinubu has been jailed, 2, that Shettima could not have contested, and 3, that Tinubu never had a 2/3 of Abuja. That is the contentious issue now before the tribunal. But when you look at the law, the Supreme Court, in 2 or 3 other cases that I'm aware of, says, look, Abuja is not a state under the Constitution. But we, Supreme Court, we accord it that status of a state. But in according Abuja the status of a state, we are not going to give it any privileges. I think it's in one of the Boris cases in the Supreme Court. So the Supreme Court says, look, Abuja is Abuja. We will not impose any privileges because it is not a state, but we regard it as a state. Now the question is, Turenchi, as the Hausas will say, the use of and. You are now saying, this says, look, you must have 2/3 in 36 states and the federal capital. So depending on which divide you are, as I always say, if you are for the proponents, they will say yes, 25% must include and will include Abuja. But if you are a constructionist, you are following the mischief rule or whichever this thing, you will know. If a man has 25% in 36 states, but does not have in Abuja, you will now say you can't be president. Does that make sense? Many people will laugh at you. And this question of 12 two-thirds, we have to be careful. By dragging in Abuja now into 36 states, we now have 37 states. Can we ever have 2/3 of 37? So we have to be very careful. But my view is this. Reading of that section, looking at all circumstances in Nigeria, you must have 2/3, generally, of all the states plus Abuja. So the word "and," whichever way the judges want to look at it, is their own headache.
Let me go back to something you said earlier about how difficult it is for the petitioners to prove their case, especially because Inec has the backing of the law. What would you say to those who already think that the courts are not likely to do justice?
There are 3 stages. So even though the Inec is given the power under the Evidence Act to be given the privilege that is now enjoying, it now says, look, to be able to jettison a petition, 1, you must first show non-compliance. Non-compliance that must be very substantial. When you show it, you must now show that it affected the election. That is stage 2. The affectation on the election is that, in what so and so, when votes were not cast, so many votes were lost there. In so and so, at the end of the day, you have to show to the tribunal how many votes were lost by your client due to those malpractices. Those votes must be so substantial that they must have affected the result of that election. So even though INEC has the privilege to have the backing of the law, it is still required to substantially produce evidence. So it is not all that difficult, but it is very rare. When you have 2 million people voting and you have only 100,000 rioting here and there, okay. Your opponents will say, okay, I give you all those 100,000 votes. I'm still leading you by 2 million votes. So even if the tribunal says I was wrong here, how has it affected the election? So that is the position at the tribunal now. Whatever